We have breaking news out of the state of California. A federal district court judge has upheld, in the case of Jones versus Bonta, the California law that says that 18 to 20-year-old Americans that live in that state can be denied the right to acquire certain types of long guns, including semi-automatic firearms, long guns, from the FFLs in the state of California. This state has been upheld over a Second Amendment objection by the Firearms Policy Coalition and the Second Amendment Foundation and others. We're going to break down this decision by the 88-year-old judge appointed to the federal bench by Bill Clinton when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and two-time nominee for the Gundy Awards 2024. Two categories I've been nominated in. We're very proud of this. First is for the top influencer who's a male, and also for the top voice of the Second Amendment. We're honored and hope we have earned the respect of others in the Second Amendment community, and we appreciate the honor to be nominated for two Gundy Awards this year. All right, folks, so in the case of Jones versus Bonta out of the United States District Court for the Southern District of California, a case that's pending in front of a Judge M. James Lorenz, an 88-year-old federal district court judge appointed to the bench by Bill Clinton. He has denied a motion for a preliminary injunction that was seeking to enjoin a California law, specifically Section 27510, that prohibits FFLs, those are federal firearms, those are federally licensed firearms dealers, from selling, supplying, delivering, or giving possession or control of firearms to individuals under 21 years of age with respect to certain long guns and semi-automatic center fire rifles. Now, this should obviously violate the Second Amendment, but the judge here concluded it did not. Specifically, what the judge pointed out is that this was not a ban on 18 to 20-year-olds being able to acquire firearms, because they could still acquire arms in various ways by getting gifts from immediate family members or inheriting it or things like this. Of course, the reality is, as you know from the U.S. Supreme Court in Heller, the Supreme Court made it clear that just because you allow access to the Second Amendment through other means does not mean that the first means is constitutional or allowed, because in that case, in Heller, of course, the District of Columbia government argued that the handgun ban was constitutional because the people that lived in D.C. could have access to rifles and shotguns, and therefore they argued the ban on handguns was constitutional under the Second Amendment. But the Supreme Court rejected that argument, saying that the fact that there's alternative means to exercise the Second Amendment rights is not a justification for a particular gun ban or other gun-related restriction. So too should the case be here, where they're saying, look, if you can't acquire a gun from an FFL, so what? You can still get those same guns, really, if you think about it, on the street, on the black market, or some other ways, without going through an FFL, which is kind of absurd, but that's how the law works. And this judge upheld it. So anyway, that's the first thing. That's the law. As to what happened here, as you know, the basic rule of the road is that when the text of the Second Amendment is implicated, the burden shifts to the government. The court wrote that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Now, this is important. We've talked about this before, but I want you to think long and hard about this. The text, the right of the people to keep and bear arms shall not be infringed. The first question, of course, is who are the people? Well, we know who the people are. The United States Supreme Court in Heller told us who the people are, which is everyone associated with America, all American citizens, which obviously would include 18 to 20-year-olds as part of the people. So as a matter of text, 18 to 20-year-olds, to the extent any of their rights to keep and bear arms are infringed upon, which means to hinder in any respect, could be to destroy or to hinder, not just destroy, but it could just be to hinder or obstruct. The fact that 18 to 20-year-olds want to be able to acquire guns like anybody else in America through an FFL in a commercial transaction, because again, one of the ways you acquire guns, the most popular way, is you buy them from a gun dealer. That's how you get guns. And the fact is that they are being prevented from being able to exercise their right to keep and bear arms because the inability to get guns the most normal way through an FFL is an infringement, right? Because this law is hindering the ability of 18 to 20-year-olds to be able to acquire guns and thus exercise their right to keep and bear arms. I think it's pretty straightforward. Nevertheless, so once the text is satisfied, the burden shifts to the government. And what does the burden shift to the government to do? The government must demonstrate, and this is what the judge says, quoting Bruin, the government must demonstrate that the regulation, i.e. the law, is consistent with this nation's historical tradition of firearms regulation. Only if a firearm regulation, i.e. today's gun law, is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Very close quote. That's what the U.S. Supreme Court said in Iserber versus Bruin, and this is what the judge here in this case, Judge Lorenz, said. Now, because the text is satisfied, the burden shifted to the government of California to justify these laws with history. And did they succeed? Well, in my view, they clearly did not, because all they did was they did two things. The first thing is they did was they basically just try to engage in interest balancing. So, for example, the judge talks all about how 18 to 20-year-olds are identified or have been identified as disproportionately prone to violence, including gun violence, compared to older age groups. That goes on to say that there is evidence that experts report that there's developmental issues associated with 18 to 20-year-olds. They're slower, or they haven't figured things out as much as getting older, and so on and so on. So basically, the judge is talking about how 18 to 20-year-olds are riskier for possessing firearms and the like, and as a consequence, there is a justification for denying them all of the rights that any other American would have. But of course, this smacks immediately of, guess what? Interest balancing. He's trying to make policy arguments about the good and the bad of guns when it comes to the right to keep and bear arms for 18 to 20-year-olds. So you can immediately say on page 12 of this decision, I'll put a link to it down below, that they're immediately engaging in interest balancing tests and arguing that guns are bad for 18 to 20-year-olds and they're more dangerous and so on. But of course, that's not how it works, because the U.S. Supreme Court has repeatedly said, both in Heller and especially in Bruin, that this kind of interest balancing is not allowed, meaning the good and the bad of guns is not subject to debate. We have a constitutional right. All the balancing associated with that right went into the Second Amendment, and that is what must be applied, because that was created by we the people when we adopted the Constitution in the 18th century. So now that we know the burden has shifted to the government, what did the government come forth with in terms of historical analogs? And again, remember, there's two things to remember when you deal with historical analogs. The first is that the burden is on the government to come forth with historical analogs to show that the how and the why of the old analog, first of all, they have to show there are actually laws on the books that are somehow relevant to 18 to 20-year-olds not being able to engage in the right to keep and bear arms. That's the first thing. And beyond that, then it has to show that the how and the why, meaning the why the laws were enacted in the 18th century, have to be the same as why the laws were enacted today. The same problem has to be addressed. And also the how, meaning like how were the problems addressed in the 18th century, and is the how the same today? The classic example I like to give is that in the 18th century there were restrictions on, for example, black powder storage. But the why there were restrictions on black powder storage in the 18th century was because of concerns about fire burning down a wooden city like Boston. In contrast, the why of restrictions on black powder ammunition by the anti-gunners has nothing to do with fire safety. It has everything to do with crime control or public safety against criminals. So the why of those laws is different, and thus that's why 18th century gunpowder laws is not an analog to justify, for example, restricting the number of rounds of ammunition you have in a magazine in a semi-automatic pistol or AR-15 today. The whys of those laws are different, i.e. why were they enacted? So with that said, what exactly has the government come up with in terms of showing that 18 to 20-year-olds can be restricted in some way from acquiring guns in these commercial transactions? Well, what they've done is exactly what I predicted, is that they have not really been able to come up with actual laws on the books that say that 18 to 20-year-olds could not acquire firearms. Instead, they've relied on very general statements by experts trying to summarize history. Remember, we've talked about that the Supreme Court was very clear that the burden is on the government to come up with actual laws on the books. Now, those laws can be, case law, it can be statutory law, it can be state constitutional law, it can be federal constitutional law, whatever it is, but it has to be actual laws. It cannot be the historical interpretation of what the 18th century meant in some way. It can't be airy-fairy history. It has to be, look at these laws on the books. These laws are analogous to modern-day laws, and thus those historical gun control laws in the 18th century can justify today's gun control laws today because the how and the why of them are the same. But that's not what happened here, according to this opinion, where the judge talks about the experts' opinions by historians being submitted on behalf of the government, and basically a bunch of statements that say things like persons aged 18 to 20 were considered infants or minors under the law in the founding era, citation to the expert report. And then a reference to a legal treatise from 1836, which of course is after the founding period because the last founding father dies in 1834. Jefferson and Adams die in 1826. So here you have a legal treatise from 1836 that states the necessity of guardians results from the inability of infants to take care of themselves in contemplation of law until the infant has attained the age of 21 years of age. So basically you have these laws that are generically talking about how people don't become full-blown American citizens until they are 21. But what is missing here are specific laws at the time of the founding that say that 18 to 20-year-olds could not acquire firearms that are analogous to what's going on here in the state of California. So again, what you have here is the judge is using very generic statements about 18 to 20-year-olds, but is not able to identify, in my view, specific gun control related items that would show the how and the why. Now, there are some laws he cites to out of Alabama and Tennessee from 1855 and 1858. But again, the Second Amendment was adopted in 1791. So what would a law adopted in 1855 or in 1858 speak to the founding generation and their understanding of the Second Amendment when it was adopted, decades and decades earlier? And keep in mind that by the time you get to 1855 and 1858, the founding generation had all passed away. The last person that died from that generation that was a founding father was in 1834 with James Madison's death. So they're using laws that come after the founding generation and should be rejected as irrelevant, because remember, the only time laws can be relevant if they were adopted after the founding generation, after the early 19th century. The only way they can be relevant is if they confirm or affirm the 1791 understanding of the Second Amendment. They are not allowed to contradict the text or to undercut the 1791 understanding. This happens over and over and over again, including, for example, the Chief Justice John Roberts' decision in Montana versus Espinoza just a couple of terms ago, where he, interpreting the First Amendment, points out that the fact that 30 state laws were on the books that undercut the 1791 understanding of the First Amendment, and those 30 laws were on the books in the late 19th century, those were rejected as being irrelevant to understanding the 1791 First Amendment in Montana versus Espinoza. So that just illustrates the fact that if you get after the founding generation, the U.S. Supreme Court just doesn't consider those to be relevant. Unless, again, they confirm or affirm the 1791 understanding. They cannot contradict or narrow or undercut that 1791 understanding. Now, last but not least, as you know, the dispositive historical fact is the 1792 Militia Act. The Second Amendment was adopted in 1791. In 1792, Congress enacted the Militia Act of 1792 that said that 18 to 20-year-olds, specifically 18 to 45-year-olds, had an obligation to bring with them to militia musters their very own firearms, their own ammunition, their own pouches, their own cartridges, which demonstrates that there's an expectation to understand that 18 to 45-year-olds all had the right and ability to acquire privately owned firearms. And that is why Congress said that law, created that law in 1792. Now, there's an attempt here by the judge to try to distinguish it in various ways by saying, well, some of the states required the parents to acquire guns on behalf of the kids. But again, none of it matters, because where exactly is the law? There is no laws, as I see it, in this opinion. You can read and tell me if you disagree, that says that 18 to 20-year-olds are not allowed to have firearms. And as a result of that, I don't see how this California law stands. And remember, never forget, and this is critically important, in a footnote in Nysurpa versus Bruin, the Supreme Court made very clear that if there's any ambiguity or close call with respect to whether or not there's historical analogs to justify modern-day gun control law, if there's a close call or ambiguity about those two things, guess what? The presumption is freedom wins, that the unqualified command of the Second Amendment shall not be infringed is to rule the day. So even to the extent you want to say that the record is a little ambiguous as to whether or not 18 to 20-year-olds have the right to keep and bear arms during the 18th century, and I don't think it's that ambiguous given that the Congress itself adopted the Militia Act of 1792 that expected and anticipated and understood that 18 to 20-year-olds would be able to bring in their own privately owned firearms, and the way they would get those guns, of course, is by buying them or getting them somehow. It shows that they had that right. And to the extent you want to argue the historical record is ambiguous or cuts both ways, remember the Supreme Court says in that situation, the Second Amendment's textual command, which is the ultimate historical document, of course, governs the situation, which in this case would mean that these laws should be struck down because all other Americans can go to FFLs and acquire these ordinary semi-automatic center fire long rifles and long guns, as well as long guns in all respect, which again, if you're 18 to 20 years old living in California, you're not able to do that with very few exceptions if you work basically for the government. So, all right, well, we'll see what happens if they take an appeal or what happens in this case of Jones. I'll put a link to it down below. Don't forget to subscribe and like this video and share it with your friends, and feel free to follow me on X at 4Boxes Diner, and we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.